Hello, my name is Larry Parman. I'm sitting here with Jerry Shiles. This is a continuation of our estate planning series. We are with the firm of Parman Easterday. We concentrate exclusively in the area of estate planning, elder law planning, and business succession planning. We've talked in the past number of sessions about different estate planning options, one of which is the revocable living trust. It's our favorite tool. We've migrated that into a legacy wealth planning tool, which we talked about before. But in addition to the revocable trust, a comprehensive estate plan should have a number of other documents that assist it and that perform where it cannot perform. So Jerry, share with us, with our audience, what some of those should be.
Well, so many people come in, especially if they have not attended one of our seminars, they've just been referred to us by a financial advisor or someone similar to that, and they'll come in and they're thinking of that estate plan as one of two things, either a will or a trust. And they'll come in and say, my financial advisor says I need a trust, and when do we get started? What they don't think about are what are those other documents that make that estate plan a living, working organism that's going to take care of them during their lifetime and as we move forward. And the first of those, the collateral group, I guess I would call them, is healthcare documents. If you don't have a healthcare power of attorney and you're injured and unable to communicate with that doctor, there are restrictions on what the doctor can provide in the way of medical care. But if you have a healthcare power of attorney that designates a healthcare proxy to make that decision for you, you can be sure that that care can be provided on an emergency, immediate basis. The same thing with a living will. If someone has, they're brain dead, they're persistently unconscious, or they have a terminal illness, we want to be able to terminate that life if that's their wish, but we've got to have authority to do so. A couple of other documents that tie into that is the durable power of attorney for finance and property, and we still need a will. Even though we have a trust, we need a pour-over will that will pick up any assets that we might have overlooked. And then there's the public filing of the trust, which is a certificate of trust that shows who has the authority to act and identifies any real estate. So there are a number of ancillary documents that need to be completed in order for that estate plan to work effectively.
And in addition, when you assemble those documents, we put them into a portfolio that includes a number of other instructions as well. It almost serves as an instruction manual about how to operate your plan after you complete it. So those are key important collateral documents that accompany the revocable living trust, make it work effectively. Jerry mentioned all of them: the pour-over will, the durable power of attorney for health care, the HIPAA form, for the privacy issues that come up from time to time, and the healthcare power of attorney, if I didn't mention that, and the financial power of attorney. So all those documents serve to aid your estate planning development and completion. Very important you have them. They complement that revocable living trust. We'll continue our discussion next time. This is Larry Parman and Jerry Shiles. You can arrange a complimentary phone consultation by calling 405-843-6100. Ask for Vicki. She'll arrange a time that works for all of us, and we'll look forward to seeing you next time.